let me just assist the court, my lord. Yesterday, we've been dealing with the dynamics of the applicability of a hearsay in court proceedings. A lot has been said about hearsay being admitted on a provisional basis, pending the testimony of the person on whose credibility that information comes from. Now, we've got Kelly, we've got Mrs. Steenkamp. Kelly says to Mrs. Steenkamp, this is my observation of the suspects who were in the house. Mrs. Steenkamp, or Warrant Officer Steenkamp, puts that in her affidavit. That does not come from Warrant Officer Steenkamp. The information comes from Kelly. Now, Kelly is again one of those witnesses that are mentioned in the list of witnesses in terms of Section 144 of the Criminal Procedure Act. Mrs. Steenkamp again is also one of those witnesses who's also mentioned in the list of state witnesses. I'm not so sure whether the state, by leading this information, is going to request the court that it should be admitted provisionally, pending the calling of these two witnesses, my lord. I just need the clarity from the state.
As a court, please, my lord. None other than the defense handed up Exhibit J. The state didn't hand it up. It's the defense that handed it up. They cross-examined at length.
Which is
on the contents.
Which is Exhibit J, so that everybody can see it.
Exhibit. There's the report of Warrant Officer Steenkamp.
So it was handed up by the state.
By the
defense.
Yes.
Is that what you are saying?
Yes. It was handed up by the defense. They cross-examined at length. They referred to the contents thereof. In fact, the contents thereof were traversed through various witnesses. And not only one witness, my lord, but as far as we remember, various witnesses. When we dealt with hearsay evidence yesterday, my lord, the hearsay act stipulates that the party against whom hearsay evidence is to be used can consent thereto, But what other inference, my lord, can be made from the fact that the defense, out of their own accord, handed up this exhibit, other than that they consent thereto, my lord. It cannot be that they use the exhibit when it suits them, but when it doesn't suit them, my lord, they object thereto. But it's an exhibit that is before court, and we submit, my lord, that Brigadier Gininda can refer to that exhibit.
Okay.
Thank you, Brigadier. Do you have...
That seems to be unprocedural, my lord.
Please, Mr. Mnisi.
Yes.
Don't insult me.
No, I'm not insulting you, my lord.
Please.
I'm expecting the court to invite, if we've got a reply to what the state has responded to, then the court simply says, okay.
Yes, but Mr. Baloyi has said you handed up that exhibit.
Yes.
What more must I do? What more must I do?
What does procedure say, my lord? if there's an objection, there's a response, is there not supposed to be a
I've got two versions, in other words, before me, so the court will decide.
No, it's fine, I'll sit down, man.
Yeah, we'll decide which version.
No, I'll sit down.